Our next topic will be the principle of security of tenure. This is very important topic, a very important right of the employee. In illegal dismissal cases, the bottom line of these disputes would be the clashing of two forces, the right to security of tenure and the exercise of management prerogative to terminate employees. So if the exercise of management prerogative is invalidly carried out, then security of tenure will prevail. However, if it is a valid exercise of management prerogative, then the employee can be validly terminated. Just like all other rights, security of tenure is not absolute. So we have to remember that this security of tenure, if confronted with a valid exercise of management prerogative, the latter will prevail. What is therefore security of tenure? Security of tenure is a right of a worker guaranteed by the Constitution. And in this right, the worker is assured that he or she will not be terminated unless there is a valid ground, which could either be authorized or just causes. And there must be observance of due process. No less than the Constitution of the Philippines guarantees this right under Article 13, Section 3. Then you also have Article 3 of the Labor Code. So the Constitution and the Labor Code guarantees this right. The next question would be, even if this right is guaranteed by the Constitution and the Labor Code, can the employee waive this right? According to the concurring opinion of Justice Carpio in the case of Laya Jr. versus Court of Appeals, January 10, 2018, this right of security of tenure by the employee can be waived. However, the waiver must be clear, categorical, and knowingly and intelligently done by the employee. So if there is waiver of this type of security of tenure, then the employer must prove that the same was done by the employee in a very clear manner, in a very categorical, knowingly and intelligently done by the employee. Otherwise, the waiver will not be considered valid. So if you will be asked in the bar examination, do not just say that this is the right of the employee not to be terminated without just and authorized causes. You have to describe that this right is guaranteed by the 1987 Constitution as well as the Labor Code of the Philippines. You must state the basis or the source of this right, but you don't have to say that this right can be waived unless you will be asked with that question, a follow-up question on whether or not this right to security of tenure can be waived. Now let's go to the next principle in connection with security of tenure. The principle of constructive dismissal. This constructive dismissal is particularly, and I considered it a threat to security of tenure. Why? Because the employee will be terminated in this case against his or her will, and it will end up to illegal dismissal. Now, what is constructive dismissal? Before going to the definition, we must remember that there are two kinds of constructive dismissal. The first type of constructive dismissal is when the employee is placed under particular situation where the working environment has become hostile, unbearable, uncomfortable, and prejudicial to the employee due to the acts or series of acts committed by the employer. The second type of constructive dismissal is what we call the application of floating status. We will discuss it one by one. Let me describe the first I discussed as the first type of constructive dismissal. So this constructive dismissal, the first type, is caused by an act or a series of acts committed by the employer. Examples would be when the employee is subjected to humiliation, threat, very embarrassing situations purposely done with the employer. It's like another way of terminating the employee impliedly. What will be the consequences under the first type? Or what will be the logical scenario? First, the employee who is subjected to the first type of constructive dismissal would either resign or go on a wall. If the employee will tender resignation and later on file an illegal dismissal case on the ground of constructive dismissal, it is allowed even if the employee tendered a valid resignation letter. Under the law or under the jurisprudence set by the Supreme Court, even a written apparently voluntary resignation can be questioned by the employee, alleging that he or she was subjected to constructive dismissal, and the case will still prosper. So in this case, it is the employer who has the burden of proof to show by substantial evidence that indeed the resignation letter was voluntarily executed and there was no illegal dismissal committed. The employee in this case will allege and also present evidence showing the facts and circumstances surrounding to the allegation of constructive dismissal. But since the employee resigns here and then the employee questions the voluntary execution of his resignation letter, then it is the burden of the employer to prove that the resignation was validly executed. Another consequence of the first type of constructive dismissal would be that the employee will go on a wall or absence without leave. So in this case, in order to protect the employer must send notice to the employee to return to work and explain why he or she went awol. And remember, regarding abandonment, it is the burden of proof of the employer. It is the burden of proof of the employer to prove that the employee, there is an act of the employee which can be shown or which can be used as a proof that the employee intended to sever employer-employee relationship. So in this case, again, it is the burden of proof of the employer to prove the elements of abandonment. Otherwise, the employee also can file illegal dismissal case, provided that it should be done within 4 years or within the prescriptive period. So that's constructive dismissal. So you might be confronted of a question or a situation wherein you will be asked, an employee who voluntarily resigned and filed an illegal dismissal case alleging others other than non-payment of monetary benefits, the employee is alleging that he or she is a victim of constructive dismissal, then the case will prosper. The second type of constructive dismissal is what we call the floating status. This is also a good source of bar examination. When you talk of the second type of constructive dismissal, which we call floating status, let's look at Article 301 of the Labor Code, wherein the employer may put the employee under floating status not exceeding 6 months. Beyond the 6-month period, the employee is deemed terminated and there will be obligation to pay separation pay. During the suspension or during the floating status, there is no obligation to pay wages to the employee because there is no work performed. Another instance of floating status is the one introduced under DO 174 in the case of security guards, Section 13 of DO 174, or other permissible job contracting, not only security services. We are talking here of janitorial, messengerial, as long as it's a valid and permissible job contracting. In this case, under DO 174, the floating status is limited only to 3 months. Beyond 3 months, the employee will be entitled to separation pay because the employee is deemed terminated. With the passage of DO 215, series of 2020, the Department of Labor issued this department order wherein the 6-month floating status can be extended in case of declaration of war, pandemic, and similar national emergencies, in which case the employer may extend the floating status of the employee for another 6 months without pay. However, we have to remember that under this DO 215, the employer must report to the DOLE within 10 days prior to the effectivity of the extended 6-month floating status. And the employee shall not lose employment even if the employee has found an alternative employment during the additional 6-month floating status. And if ever retrenchment is necessary, then the employer shall pay separation pay. If there is a CBA or a company policy which provides a higher rate for separation pay, the same shall be applied. And those retrenched employees under this rule, they shall have the priority when it comes to rehiring the employer if they indicate their intention or desire to resume work not later than 1 month from resumption of operation. The employees may be called to work prior to the extension of the period, or the employees may be retrenched and separation pay will be given. And when we talk of separation pay, the first 6 months of suspension shall be included in the computation of separation pay, which will give rise to another 1 year of service. And since in retrenchment, 1 year of service means either 1 month or 1/2 month for every year of service, whichever is higher. So to summarize, there are 2 kinds of constructive dismissal. The first type wherein it is the employer who will cause the working environment to become hostile on the part of the employee, and the employee will either resign or go on a wool. And the second type is when the employee is placed under floating status and the floating status period has expired, then the employee is being terminated or constructively dismissed. Before I end this topic, we have to include also other circumstances that will lead to constructive dismissal due to the act of the employer under the first type. A common example would be an invalid demotion, a demotion wherein there is no ground available. So if the employee is demoted without any legal basis, then it is an invalid demotion and the employee is a victim or subjected to constructive dismissal. The employee would either resign or go on a wool. Another one, if we recall in our discussion in management prerogative, an invalid exercise of management prerogative to transfer is also constructive dismissal. And with that, we will go to the next topic, which is preventive suspension under Rule 13, Book 5 of the Implementing Rules. This preventive suspension is in nature an exercise of management prerogative to protect its property, the life of the owner, or the life of the co-employees. And the reason why the employee is placed under preventive suspension is to prevent the employee from committing further acts that would lead to damage to property, loss of life, or threat of life to the owner or the employees. So this is the preliminary portion of the disciplinary measure imposed by the employee. And under this rule, the employer is given 30 days as a form of limitation to finish the investigation and place the employee under preventive suspension without pay. The legal basis for non-payment of wages during preventive suspension is the principle of fair day's wage for a fair day's work. Since the employee did not render work, then there's no obligation to pay wages. However, if it is proven that the employee is not guilty of the offense allegedly committed, then the employee will be entitled to back wages for the 30-day suspension period. Now, what will happen if the investigation is not finished and the 30-day period has lapsed? Then there is the obligation of the employer to reinstate the employee, either payroll or actual. Otherwise, there will be liability for illegal suspension and there will be payment of back wages. Not only back wages but other benefits due to the employee during the period, and also when the employee is found or exonerated as a result of the investigation. The first thing that you have to remember, in addition to the exercise of this prerogative to protect its property and the life of the owner of the co-employee, there must be proof, or the employer must be convinced that the employee's presence or continued presence would pose a serious and imminent threat to the life or property of the employer or of his co-employees. So if the offense committed by the employee is by sleeping during office hours, then there is no basis for putting the employee under preventive suspension, because the continued presence of the employee is not a serious an imminent threat to the life or property of the employer or co-employees. However, the situation would be different if the employee committed the act of misappropriation or misappropriation of the funds of the employer. For instance, in the case of a cashier, if you will allow the cashier to continue working, then there is a high probability that the cashier will continue misappropriating the money of the employer. So during the 30-day suspension period, the employee must be given ample opportunity to defend his or her side. A hearing is not mandatory unless it is requested in writing by the employee or there is a company policy or when the circumstances justify the conduct of a hearing. Other than the three, then there is no reason to conduct an administrative hearing, and it is enough that the employee is given the opportunity to explain his or her side using an affidavit or even a letter. The right to counsel is not even mandatory. However, if there's a hearing, the employee can bring his or her counsel. So after the finding of the investigating committee that the employee committed offense as charged, then it is now proper that the committee will endorse and recommend the imposition of penalty. The penalty could either be suspension or termination. If there is penalty that is imposed here for suspension as penalty, this time suspension becomes a form of penalty, not anymore preventive. So it could be 3 months, 4 months, as the case may be, depending on the penalty imposed under the company policy. Or worst case scenario, the employee can be terminated because the offense is serious that would merit termination of employment. Based on that discussion a moment ago, suspension could either be preventive suspension or suspension as a form of penalty. These two kinds of suspensions are different. If you will be asked the 2 kinds of suspension, then you will just answer preventive and suspension as a form of penalty. Suspension as a form of penalty, there is no limit as long as it is provided in the company policy and validly done in the exercise of management prerogative to discipline its employees. When you talk of preventive suspension, there is a limit only up to 30 days.